Judgment in the matter of the Queen on the application of Hemmati and others versus Secretary of State for the Home Department.
Lord Kitchen will explain the decision of the court.
This appeal concerns 5 individuals, the respondents, who arrived in this country illegally in 2014 or 2015 and claimed asylum. They either presented themselves to the authorities on their arrival or were held soon afterwards, and each of them was placed in detention. Inquiries soon revealed that all of the respondents had already claimed asylum in another state of the European Union, and so the Secretary of State asked those states to take responsibility for examining the claims as they were required to do under a union law known as the Dublin III Regulation. In time, each of these states agreed to take the relevant respondent back for that purpose. Eventually, all of the respondents were released from detention, in some cases after a few weeks and in others after a period of months. In these proceedings, they contend that their detention was wrongful and that they are entitled to compensation. The Court of Appeal, by a majority, held that they were wrongfully detained and that they are entitled to damages for false imprisonment. The Secretary of State now appeals to the Supreme Court against that decision. This court decides unanimously that the appeal must be dismissed. The appeal raises important issues of principle concerning the limits of the power to detain, which is conferred on member states by the Dublin III Regulation, whether the detention policy published by the Secretary of State satisfied those requirements, and if it did not, whether any applicant for asylum who was detained under that policy is entitled to compensation under domestic or union law. The Dublin III Regulation allows national authorities to detain applicants for asylum so as to ensure that they are transferred to the member state responsible for examining their claims. But it does so subject to strict safeguards in order to give such applicants a high level of protection and because detention is a serious interference with their liberty. The regulation therefore makes clear that there must be a significant risk that the applicant will abscond. The risk must have been identified after an assessment of the facts of that applicant's case, and detention must be a proportionate way of dealing with that risk. What is more, the risk must be assessed on the basis of objective criteria defined by law. The Court of Justice of the European Union has provided guidance as to the meaning of the regulation, and in particular the expression defined by law. It has emphasised that the detention of applicants for asylum amounts to a limitation on their fundamental right to liberty, and so any law which authorises that detention must be clear, predictable, and accessible, so as to avoid any risk of it being applied in an arbitrary way. Member states must set out clearly in a binding provision the objective factors which will be considered in every case in deciding whether an applicant may abscond. In the words of the Court of Justice, the objective criteria underlying the reasons for believing that an applicant may abscond must be established in a binding provision of general application. The law of the United Kingdom permits immigration officers to detain a person in the immigration system until a decision is made whether to direct that the person should be removed and until the removal takes place pursuant to such a direction. In carrying out these activities, immigration officers must follow the instructions given to them by the Secretary of State unless there are good reasons for not doing so. At the relevant time, the Secretary of State's policy was set out in instructions issued in 2015. But these provided no more than general guidance as to how the power to detain was to be exercised. They did not provide a complete list of the factors to be taken into account, and some of the factors which were listed were likely to be of little or no relevance to the assessment the authorities were required to carry out in dealing with a person who was subject to a Dublin III removal procedure. As a result, the instructions did not set out clear boundaries for the assessment of whether such a person might abscond, did not identify the criteria which were to form the basis of the assessment, and did not set out the limits of the discretion of the authorities in a way which was binding and known in advance. What is more, they lack the qualities of certainty and predictability necessary to constitute a law for the purposes of the regulation. For all of these reasons, they did not meet the requirements of that regulation. The respondents were therefore detained unlawfully. A person who is detained unlawfully may bring a claim for false imprisonment. All he or she has to prove is that he or she was directly and intentionally detained by another person, and the burden then shifts to that other person to show that there was a lawful justification for the detention. Here, each of the respondents was detained by the Secretary of State, but she cannot discharge the burden that lies upon her of showing that the detention was lawful. A claim for damages for false imprisonment is not a claim for damages for a breach of European Union law. The public law error made by the Secretary of State bore directly upon and was relevant to the decisions to detain, and those decisions lay outside the scope of any permissible exercise of the power which was conferred upon her. What is more, it is no answer to such a claim to say that detention would have been lawful had the law been different. It follows that the respondents were all unlawfully detained and are entitled to damages under domestic law for false imprisonment. In these circumstances, it is not necessary to consider their claims for damages for breach of European Union law. The proceedings will now be transferred to the County Court for the assessment of those damages.
Thank you. The Court will now adjourn.